Hi, I'm Linda Anderson, and I just want to talk briefly about how to be an excellent healthcare power of attorney agent. The idea is that you may be tasked to make important medical decisions for somebody. Perhaps it was an unexpected event, perhaps it's expected because the person may have had a decline over a period of months or years. The idea is to understand that when you're an agent, you step into the shoes of the person, the principal, who's actually made the selection to make those medical decisions. Whether it's the principal or the agent, many times the types of decisions that are made relate to giving informed consent for medical treatment. When a healthcare provider is trying to get that informed consent, it's their responsibility to explain the pluses and minuses of the treatment and whether there are any other options. And your role is to then decide not perhaps what your personal preference is, but to look at the information you have and do what your principal has asked you to do. Many times the most difficult decisions are end-of-life ones, and so as a healthcare agent, you're relying not only on the document that appointed you as a healthcare agent, you may be relying on what's called an advance directive or a living will. That document is triggered when somebody has an end-stage medical condition or is permanently unconscious. Your first role as a healthcare agent under these circumstances is to make sure that you agree that your family member is actually end-stage medical condition or permanently unconscious. End-stage medical condition means death is imminent, irreversible, and even with the introduction of medical treatment, there's 100% certainty somebody's going to pass away in the very, very near future, whether it be an hour or a day. And so if you are not sure that somebody is end-stage, you can make a decision to say, no, the living will, the advance directive is not operative. Permanent unconsciousness, the best case that we have to illustrate that was the Terry Schiavo matter, where she was maintained for 15 years with a feeding tube, even though there was absolutely no brain activity. Unfortunately, in Pennsylvania, or fortunately, depending on your view, there is a very conservative policy represented in our law, which will presume, if we don't know expressly what your wishes are, and we can't infer it from what you might have said, that you do want a feeding tube, even if you're permanently unconscious. So one of the best things we can do in order to make sure that somebody that really does not want a feeding tube, if they're permanently unconscious, is to make sure that they express that, and no better place to express it in the living will or the advance directive. Your job then is to actually consider those instructions and make sure, as the advocate and the surrogate decision maker, that you're implementing these important decisions. When does your authority end? It ends when the person passes away. There is some law that says organ donations that go beyond when somebody dies are also within your purview. There's some actual other provisions that say it's important to go back to the principal and see if there's a countermand. And so again, another part of Pennsylvania's statute that really relates to the goal of preservation of life, similar to the feeding tube issue, is to make sure that even if the person is not of sound mind, if there's a countermand, that we actually may have to continue with treatment. How to navigate these very important medical decisions is not always obvious, especially if there are dynamics between the family members or the family and the healthcare provider. If you need any more information, please feel free to call us and we will help you.